One, directing the matter to go out of this legal. They are not okay. Petition mirror is part by principle of restriction because we have a similar kind of petition that was rejected by the Jharkhand High Court. Both mirrors report a single bench as well as petition bench. They are challenging the promotional process of 2010 and it went up to the Supreme Court. Rejection was there. Now challenging the same mirror they are now online. Now the problem is since they have already received the compensation. Petition. They have raised the issue of claiming that it is barred by the how will you satisfy this point? How radical? Let me hear from a lot of friends. How it is barred? Because it is not reopening or re-deciding an issue already decided in the earlier case. Let me now clear it that I am by this petition. He is saying that the issue was decided by the High Court. Subsequently, the matter went up to the Supreme Court. Yes. Supreme Court affirmed the decision of the Calcutta. And hence the issue has finally settled. You are trying to again reopen the same. No, I am not trying to reopen the same. Okay. So, my lord, then my lord, as it said from your lordship, as my lord said, good or submitted, that it is not a case of reopening. Why? Rather, my lord, by this petition, as I have submitted earlier questions also, I have prayed for implementation of the order passed in the earlier petition filed in order passed by the Jharkhand High Court. It is an application for implementation, not deciding the issue again. Whatever decision has been rendered, let it be decided and let it be implemented. Nothing more, nothing less. This prayer cannot be termed as to invite the Honorable Court to decide again the issue. So, my lord, that once an issue has been decided in my favor, then I will again re-agitate the same. Okay, now kindly come to the fact and give a reminder. So therefore, my lord, it is not a case of reopening the issue already decided. Okay. Rather, it is for implementation of the earlier decision rendered by Honorable Ranchi High Court. So, my lord, I am placing before lordship the facts of the case. Okay. But there was a notification, my lord, on 16th November 2010 for selection under Rule 72 of the Appeal. I will come just later. what the rule 72 says. Or probably I need not place all those things because it has already been decided. But that was a case of selection for promotion to the post of ASI by selection under Rule 70, who were having at least 10 years of service experience in the lower grade, that is constable expert. But the petitioners applied, their applications were verified and found. They are found in selection was done. You were selected. Select list was prepared. And select list was prepared. Then, my lord, thereafter, there were some stages which they disclosed during the pendency of the restriction report. That the select list were higher authority for approval. The higher authority not being satisfied with the higher list. Whereby the Chief Security Commissioner rejected the select list. Rejected the select list. Challenging again, my lord, and thereafter fresh selection notice was issued. Fresh selection notice was issued. Yes. My lord, earlier selection was cancelled. If you also kindly come to page annexure P2 to my repetition. Annexure P2 to my repetition. Page what I am saying, 34. 30. Second paragraph, consequent of such cancellation of the select list or promotion to the rank of national sub-inspector under Rule 72 of the earlier notification bearing number 708 and letter even number 16 also here vacancy. This particular notice, my lord, of cancellation as well as holding for the fresh selection was carried in a restriction filed before the chief. My lord, during the pendency of the restriction, an interim order was passed. For in the circumstances that there are further steps taken by the authority for selection, as well as this one. Then the Honorable Rajasthan was pleased to pass an interim order. Honorable Lordship kindly come to paragraph page 45. No. Interim order, page 39. Page 39. Page 39. And should be 5 page 39. Yes. Respondent shall place on record the internal vigilance group IVG of RPF as mentioned in paragraph 5 of the complaint and for the next fixed list of things. Any selection for promotion to the rank of assistant sub-inspector RPF pursuant to the institute order shall be subject to final result of the examination. So, my lord, whatever selection was made, that will be subject to the result of it. Therefore, my lord, some other repetitions were filed because some other repetitions were. And in those repetitions, my lord, also those repetitions were disposed of by a judgment which starts from page 40. And my lord, the operative part 46. To publish merit list and in view of thereof, I dispose of the batch of petitions by directing the respondent to publish the merit list and to operate the same in accordance. However, it is made clear that appointment that might be made from such merit list would be subject to the and abide by result of the restrictions pending before the Ranchi. Therefore, whatever appointment given by reason of the selection made subsequently, they are failing by the result of the petition pending before the Ranchi High Court. Yes. Then, my lord, ultimately, the Honorable Ranchi High Court disposed of the writ petition. My lord, it starts from page 48 and page 59. Page 59 says the order of cancellation and letter dated whereby case willingness was called for by the letter dated from the head constable and told who had completed 10 years of service on the date of the respondent directed to take immediate step for publication of the selection list. But I am on this. I am on this. Everything set aside. Therefore, by virtue of the interim order, the appointment already given also given go by. The appointment goes. I am not now on those. But I am in this definition praying for implementation of this specific direction to the respondents to take immediate steps for publication of the select list and for withdrawal of the fresh notification dated to the period of 6 months on the date of receipt of the copy of the appeal was filed. It was the division bench. That was dismissed. SLP paper also that's conception by the petitioners. Well, that was also dismissed. Therefore, my lord, the judgment of the Honorable High Court has settled final. And you now want enforcement of that. But they are taking the advantage. Probably, my lord, my management has already made submissions regarding some paragraph and a direction given by the division bench of the Honorable Ranchi, whereby direction was given to pay some compensatory amounts due to loss of seniority, due to non-publication of the select list. That is not the subject matter. You just want enforcement of that order. Yes. Passed by the along with yes. If I want that the select list should be published. Published. With effect from the date when the selection was complete. And to operate it in accordance with not more than that. Anything. Calcutta High Court also wants valid justice before the yes. Was directly in the same line. So nothing has been decided on merit either by the Supreme Court or by the since my lord has taken this point, resuming at whether implementation is permissible in the subsequent repetition. I will rely upon one judgment. My lord, it is my lord rendered by Honorable Justice for this standard. Citation again, CLJ 2011 volume 3, page 72. Volume 3, 72. Yes. Then after some division with judgment, ultimately by opposition laid down in this judgment is that whether any writ for enforcement of the order passed in earlier writ can be filed or yes. Yes, mention it. Yes. Why? The lordship kindly considers. I will just place the few facts before coming into this. Lordship has already seen the order dated 8th of December 2011. The Lordship kindly considers page 34 for a moment. But the basic purpose of page 34 was that may just read two paragraphs, not but 2 paragraphs. It is further mentioned that is fresh notification for holding of the selection for promotion to the rank of page 34. 34. Yes. Oh, yes. It is further mentioned that the fresh notification for holding of the selection for promotion to the rank of Assistant Sub-Inspector RPA under Rule 72 will be issued after assessing the additional vacancies arising during the intervening period with necessary certification from Deputy CPO RP stroke GRC. At that time, fresh willingness will be obtained from the eligible staff. The appearing of the candidates in the selection test for promotion to the rank of ASI RPF under 72 of RPF 1987, which was held at RPF Courtroom from 18 January 2011 to 21st January 2011, and supplementary test from 16th of February 2011 to 18th of February 2011 should not be counted towards their eligibility in future. You are requested to implement the above information among system. This was the order. Now, my lord, they are for me. It cannot be done in this fast. It cannot be done. Oh, okay. Allow it to place his case. I will show, my lord, how, my lord, they have, suppressed material fact before this honorable court, and praying for a relief, in a camouflage manner. I will show. I will just, take your lordship, page 46 for a moment. Before that, if your lordship kindly comes to page 45, 24th of December 2013 order, this honorable court passed an order. Lordship kindly see the first paragraph. The petitioners as constable of the railway protection force, they were considered for promotion to the post of assistant sub-inspector. It is not in dispute that the final list of selection is yet to be published on the ground that during the process of selection proposal for amendment of the promotion has been looked at, which is pending. Then the catena of judgments discussed. Thereafter, Lordship did not look into. Lordship kindly sees paragraph 3 of page 46. In view thereof, I dispose of the batch of petitions by directing the respondents to publish the merit list and to operate the same in accordance with law. This direction was passed with the rider that whatever may be the outcome, of the decisions pending in Rajki High Court, this direction was passed. If the appointment is made. Yes. However, it is made clear that any appointment that might be made from the merit list would be subject to and abide by the result of the petition pending before the Rajki High Court. Now, Lordship kindly considers what was before the Rajki High Court. Page 48. I will just take your Lordship to this. The parties, because my consideration before your Lordship is Lordship kindly see whether the parties are safe and whether the issues are safe. If these two criteria are fulfilled, the res judicata applies. Now, Lordship kindly considers, serial number 11, the present petition along with others. All parties are safe. I will take your Lordship one by one. Lordship kindly sees, take note of the parties first at page 48. Now, Lordship kindly considers, the subject matter before the Jharkhand High Court. This order was passed on 3rd of November 2017. May I just read it for you, Lordship? I will not read the entire text, but I will just for the purpose of showing the issues are same. I will just request you, Lordship. Lordship, may kindly have a look at the first paragraph onwards. Page 51. The petitioners filed 3 petitions have approached this court. I am reading from page 51. Have approached this court with a common prayer for quashing of the order issued on behalf of IG Chief Secretary, Constable Railway Protection Force, Southeastern Railway, Kolkata, as contained in letter dated 8th of December 2011, as I have indicated, at page 30. Whereby the Chief Security Commissioner RPF Southeastern Railway, Kolkata, has cancelled the promotion selection withheld them selection test held with them 18th of January 2011 to 21st of January 2011, and from 16th of February to 18th of February 2011.
from promotion to the rank of assistant sub-inspector, railway production force, and also cancelled the earlier notification dated 8th of September 2010 and 16th of September 2011. And further decided to issue fresh notification for holding the selection test for promotion after assessing the fresh vacancies also arising during the intervening period by obtaining necessary certificate from the Deputy Chief Personnel Officer RP Kolkata. Further prayer has been made for a direction upon the respondents to complete the process of present selection by issuing the order of promotion to the rank of Assistant Sub-Inspector RPA, for which selection was held at Zonal Training Institute. Should we kindly consider these two aspects? It was raised. Further prayer has also been made for a direction upon the respondent authorities to stay of operation of the order dated 8th of December 2011. The petitioners have also prayed for quashing fresh notification dated 2nd of January 2012, issued by respondent number 14, whereby a fresh willingness by 7th of February 2012 were called for from the head constables and constables who have completed 10 years of service on the date of the notification dated 2nd of January 2012. The factual exposition, as has been delineated in the petition, is that petitioners were appointed in the railway production force about 11 to 12 years back, and some of them have also been promoted to the post of head constables by virtue of their selection and promotion. The railway production force is governed by RPF Act rules and regulations, as well as governed by the general and special laws of the land in India. And according to those, these are provision in Rule 70 to 72 of RPF Rules 1987 for promotion from rank of constables to head constables and further to the post of assistant sub-inspectors SI and inspector in RPF. It is further submitted that as per RPF promotion rules, the constable and head constables who have completed 10 years of minimum service in the force are entitled and eligible for promotion to the rank of assistant sub-inspector on invites application for the vacancies under Rule 72 of RPA Rules 1987. A duty
has been casted.
anything like that. Has not been not eligible. The duty has been casted on superior officers of the force to find out the vacancies of the post in all categories of rank to invite applications every year. All the vacancies by promotion and in view of the new selection should be held for the promotion. However, this desire of the governor is not being entitled to negligence on the part of the superior officers of the force. And hence, the members of RPF suffers from the benefits of timely promotion in spite of meritorious service considered by them to RPF. It is further submitted that the railway administration of the Southeastern Railway decided to hold a selection
promotion committee was constituted.
Yes.
And
then departmental promotion committee was constituted by headed by the Deputy Chief Secretary, Commissioner RPF.
And selection test was also held.
Yes. Outdoor test as well as vivacity test. It was fixed sometime in 19th of January 2011. Then Lordship may kindly skip over to from the middle of page 53. Total 24 candidates,
Yes.
including the petitioner, were declared successful in the examination. Thereafter, vivacity test of 20 marks were conducted by the departmental promotional committee. Then the candidates were spared back for their own place of posting in Southeastern Railway for resuming their duty. On 20th of January 2011, letter was issued for fixing the further date from 16th of February 2021 to 18th of February 2021 for the candidates who could not appear in the main examination held from 18th of January to 20th of January 2011. As requested, the date for main examination has been fixed from 16th of February 2011 to 18th of February 2011, but no one became successful in the examination. Lordship kindly takes note of this. Thereafter, the DPC finalized the selection list and submitted the same to the office of IG Chief Security Commissioner Kolkata for approval by Deputy Chief Security Commissioner RPA, who invited the application and constituted the board for selection. The petitioners were waiting for publication of their selection list of panel with much anxieties and agony, but the delays started taking place in the order of promotion. When the result was not published for a long span of period, the petitioners represented before their controlling officers at Ranchi, Bokaro, and other places of their posting, and the office of the Chief Security Commissioner of Kolkata, but no replies have been given to their said representations. When no heed was paid to their said representations, the petitioners sought information to their counsel via application dated so and so under RTI from the PIO. The PIO, in a letter dated 22nd of September, asked from the petitioner to deposit a sum of rupees 1 lakh for providing the said information. Against the said letter, petitioner advocate wrote letter to CPIO, but the same was remained unreplied. When the petitioner were waiting for the results, all on a sudden, by a letter dated 8th of December 2011 was issued by the Deputy Chief Security Commissioner RPF, stating therein that IG cum Chief Security Commissioner RPF has cancelled the selection test from promotion to the rank of Assistant Sub Inspector into administrative prisons, and also decided that a fresh notification for holding selection process for promotion will be issued after assessing the additional vacancies arising during the intervening period, with necessary clarification from the Deputy Chief Personnel Officer, Garden Reach, and then fresh willingness will be obtained from the eligible staff. Being agreed by the imprimed order dated 8th of December 2011, the petitioners presented before the respondent authority via their representation dated 16th of December 2011 for redressal of the grievances, but to no avail. Hence, the petitioners have knocked the door before this court. Now, under the submissions of the learned council was recorded. Then, the ultimate paragraph. Yes, the Lordship, kindly have a look at page 56 from the green report. Paragraph 10. As the Lordship got to page 56, paragraph 10. Be that as it may, having gone through the rival submissions of the parties, the court is of considered view that the cases of the petitioners need consideration. The respondents have illegally and arbitrarily rejected the cases of the petitioner. Names appear in the final
Yes, I have read lastly the order of cancellation and the letters or by fresh willingness were called for are all cancelled.
The paragraph 12 is not the ultimate of paragraph.
Right.
Lordship kindly considers as a cumulative effect of the aforesaid facts, rules, guidelines, observations, and judicial pronouncements, I hereby set aside and quash the order of cancellation and also letter dated 2nd of February 2012, whereby a fresh willingness were called for by letter dated 7th of February 2012 from the date constables and constables who have completed 10 years of service on the date of this press notification dated 2nd of January 2012. The respondents are directed to take immediate steps for publication of the selection list and for withdrawal of the press notification dated 2nd of February 2012, preferably within a period of 6 weeks from the date of receipt of a copy of this order. So, this was the sum and substance of the order. Initial notification was cancelled, and there was a direction with regard to the fresh notification. Now, Lordship kindly considers page 60. Challenging this, the government of India went up in appeal. Lordship kindly sees
The appeal was ultimately dismissed.
No, but before that, Lordship may kindly have a look at page 61. The area of parties, if your Lordship kindly have a look at the same petitions. The petitioner number, the respondent number 11 is the petitioner number 1 here. The other petitioners are also there. Now, Lordship kindly considers page 62 onwards. This order dated 14th of July 2022. The government went up in appeal, And Lord, your lordship may not look into the facts of the case. It is almost accurate, but I have read out.
No, you could have claimed or you could have taken this step that they could have approached the Ranchi High Court with an application for contempt. They could have single bench of the Ranchi High Court.
Lordship, kindly consider. I'll just take your lordship 2 minutes. Sir. Lordship, kindly see the honorable division bench direction first. Lordship, kindly see. Paragraph 34 at page 72.
Yes.
As he would appear on a class at the aforesaid rules promotion under Rule 72 is merit selection, whereas Rule 70 lays down the procedure for regular promotion in the cadre of ASI. A constable, head constables with 10 years of qualifying service gets a kind of out of turn promotion if he qualifies under Rule 72. All the respondents were selected under Rule 72 and except so and so, others have been promoted in the rank of ASI under Rule 70. On account of illegal and arbitrary cancellation of selection list, they have suffered loss of seniority. No doubt a selection list candidate has no legal right for selection, but cancellation of the selection list, this is a specific observation. No doubt a selection list candidate has no legal right for selection, but cancellation of the selection list having been found illegal and arbitrary, they must be compensated in terms of money. This was the specific observation made. Why I am highlighting this, lordship, kindly consider this. Thereafter, Lord, paragraph 35. Having considered the entire facts and circumstances of the case, we are of the opinion that the contesting respondents before us may be compensated by awarding compensation of rupees 50,000 each. Ordered accordingly, so and so shall be promoted in the rank of so and so on and from 14th of July 2022 by creating supernumerary post if there is no vacancy. Now, Lord, they have already taken compensation.
Yes.
Now, Lord, they are taking compensation.
Not in view of their promotion. In addition, their promotion.
All of them have been promoted.
In addition of their promotion.
For the
Which they required he got in 2010. You raising a subsequent fee, you have given it in 2020 or anything, and hence direction was given. This scope should not go into the merit of it. Yes, one short direction has been sought for in this that for enforcement of the order
permission that cannot
as well as by
that cannot be done because all these facts have been decided by a competent court of honorable division bench of Ranchi High Court. Now, Lord, after the dispute has set at rest, my learned senior friend is trying to reopen the issue again. Through this honorable High Court, which doesn't have any jurisdiction.
I am not allowing him to reopen the issue.
This particular
only the direction which was passed by this court as well as the Ranchi High Court. You just publish the things.
The merit list, entire merit list has been turned down. Lordship kindly considers the paragraph 34 for a moment. Lord, it is saying that no doubt the selection list candidate has no legal right for selection. But this
but that doesn't mean that you will get arbitrary power to cancel as and when you will so desire.
2010
selection. Yes, that is a settled.
May I just take your lordship to the single bench order again. This particular one of the single bench was of the view. Lordship kindly considers page 59 for a moment.
Yes.
The direction was to set aside and quash the order of cancellation. This is number one. And also letter dated 2nd of February 2012. Lordship kindly sees the 2nd of February is letter for a moment. Lordship, may kindly have a look to annexure P4 page 37. It was dated to the fresh notification for holding of selection from constables and constables for the promotion to the rank of ASI. But this particular notification was also considered and quashed. Now it becomes the same the petitioners does not have any kind of right to re-agitate
Okay. I have got your point.
Now Lordship kindly considers this the issues before I have also copied may I just place the copies of the petition before the Ranchi High Court. You can consider some prayer as well.
Okay, I have got your point.
The entire Lordship kindly considers the
Here you consider in this way, this court is not going to the bill. This court only will consider whether they are entitled to get an order to enforce the order. Whether the order, enforcement of which is being sought for, is validly given or not, that is not the lookout of this court. Yes, the order which was passed by the Ranchi, appeal was preferred in division bench. The appeal was dismissed. The matter went up to the Supreme Court. Supreme Court dismissed the SL. Okay, so issue so far the cancellation of subsequent selection has attained finality. This court has got no authority to reopen the same. But even so, if you invite me again to enter into the merit, that will be a fertile exercise.
Not their
scope
is substantially based on reopening of the issues again.
No,
it cannot be considered because it is not as till
so even Mr. Chakraborty, what they will do with this merit list, you just publish it.
2010 merit list has become redundant now. Lordship kindly considers
it is your claim.
This is
it is your claim.
Lordship kindly considers when this order was passed, Honorable Supreme Court as well as this Honorable Division benches, Lordship kindly considers the dates. The Honorable Division bench of Ranchi High Court passed the order on 14th of July 2022. Now, they are in the year 2025 is trying to reopen the issue again, which is 2010.
Whether it would be reopened or not, he will just publish the list.
The publication of merit list has become redundant. Lordship kindly considers two things. Initially, there was a challenge, made before this honorable court. This honorable court, has come to a conclusion that entire thing is placed before the Jharkhand High Court. So I do not have any kind of jurisdiction over this issue. So, the entire thing was remitted before the Honorable Jharkhand High Court. If at all, may I just consider this? If at all, they are equipped with the publication of merit list, they should have paid before the Honorable Jharkhand High Court, not before this court. They are taking from judgment of the Honorable Supreme. This kind of delay, Supreme Court has specifically deprecated. A person who is claiming the order from a court of equity, you should not sitting idle, you should not be in the outside. Yes.
Yes.
This is very recent.
Yes.
Justice Narsimha. This is in between Minmoy Maiki versus HON'BLE and others. Citation I have seen, sir. 2024, SC 318. Lordship kindly consider
another issue, Mr. Chakraborty,
no, the same thing. Lordship kindly see
related approach in the jurisdiction. Related approach. That is another.
This is related approach. The petitioner did not ventilate his case, although there was a specific clarity that in case there is any outcome which is in your favor, if the Lordship kindly sees the single judge's order, first the interim order which was passed.
Yes. Subject to the result.
Yes. Thereafter, they sat idle. And now they are trying to reopen the issue by way of making a repetition before another high court. They should have made it before the Jharkhand High Court itself.
Okay.
And look, they have not accepted compensation. They have been promoted by the passage of
Okay,
time.
okay. But I will not, why not? Not whether the compensation will be sufficient and whether since they have received or any order of for payment of compensation was passed in their favor, whether that will
That
yeah,
compensation
was
was
their
in
right.
Roshi kindly sees, not the honorable division benches order. That compensation was in lieu of their selection list.
Okay, you have done.
Now, Roshi kindly, not my opposition from.
Okay, yes, in the said batch of petition, it transpires that that portion to operate the respondent
To operate the
yes.
in accordance with
I disposed of this batch of petition by directing the respondent to publish the merit list and to operate the same in accordance with law. That means that portion to operate the same in accordance with law was the issue dealt with in the division bench
in my
by the Honorable High Court.
No, otherwise there is no point of
Previous portion,
Kindly for a moment. We
by direction was given upon the respondent to publish the merit list has neither been marked with any order passed by any higher court, not been set aside or consent.
because of that, they went up
By any subsequent order. Nothing legislature, our constitution delay such and such all self-imposed restriction which we have imposed upon us.
Yes,
Another section. You do delay, it is constitutional.
Lord, it is a
If
constitutional
find that they are
technically considers
then the constitution
who is not outside the position.
okay, you
Your
know,
Lordship kindly considers for me.
let us
Section 14 will come to my head. Section 14 of the limitation.
There is no, there cannot be any quarrel to regarding the binding precedent set in the judgment cited by Mr. Because this judgment deal with the issue of delay in approaching the by any litigant in their jurisdiction. So, it speaks. So 210 days, so a judge will be disposed of 210 matters in a year. You see, you have taken much more time. Go. Next.
Taking advantage of the own law, I don't talk it. Now they are taking the plea of it. They are taking advantage of their own law.
Okay, next.
I don't know, say.
Yes. Not the same. Yes. It will go down to the list. Okay. Yes.
Respondent number 7.
Yes. Item number 4. What is the application?
Well, substitution application has been filed by the petitioner. Well, thereafter they filed the delay application. Well, can you see your lordship can be the last order 13th August of 2024.
Frivolous petition.
This is frivolous.
Frivolous petition. On the same land,
co-deed petition was filed by both individual persons.
Sole petitioner.
Isn't Sheikh Abadat Ali, during the pendency of the writ petition, retired.
Ibadat Ali, alias and other were the original writ petitioner. Now, Mohammad Sahab is okay, yes. Now who died?
Yes, Sheikh Ibadat Ali died.
Okay, see, they are not coming.
Ramne said, well, this petition is pending since 2020. I'll be sure of that.
Other 5 petitions also dismissed.
Other 5
Appeal also dismissed on the same line.
Okay, next date. What do you want? The next date. It adjourn hearing. Today is the first day I am sitting. Okay, next date. এটাও তলে নামিয়ে দেবেন তো একদম।
Well, the written is position, if it matter will call and then dismiss for people. Otherwise, it will again in the bottom of the list, my lord, we have to watch.
Okay, not today.
Well, not this week.
Not this week, yes. Not this week, but এটা written রেখে দেবেন, বুঝলে? এটা তলে না। 5. Number 5. Okay, তলায় পাঠিয়ে দিন।
Time for the petitioner, my lord. Occasion, my lord, directed the respondent to file opposition. He did not file opposition. State and council.
So if they don't file, you move your petition. Your apartment, they have chosen to be left uncontroverted. If you want to get any advantage therefrom, you can get. Not today, no, or not this week, not today. Not today.
Well, I am for the Union of India, my lord.
Where is your P?
My lord, no, my lord. I want to file everybody in opposition, my lord. I want extension of time, my lord.
I am for the petitioner. He will also kindly see the order passed by this honorable court. Kindly see the order.
How much time?
Kindly fix any date, my lord. Kindly keep 2 weeks time. I will prepare it.
Please, I will make my submission, then he will also kindly decide. I will kindly see the order passed by this honorable court. It is a contested order passed by this honorable court. Kindly see the order. Affidavit of service filed in court today is taken on record. The matter is heard only on the question of interim order at this stage. The validity of the decision of the appellate authority in upholding the cancellation of the contract, forfeiture of the security deposit, etc., will be decided after final hearing. The issue of unjust enrichment will also be heard at the final hearing. The question is whether clause 19.1 would entitle the authority to forfeit the security deposit, which was an amount secured by the petitioner for the performance of the contract for a period of 2 years. The contract was terminated within a period of 19 days. Penalty was charged from the petitioner in terms of clause 19.1 of the contract. Petitioner paid the penalty. Forfeiture of security deposit permitted under the said clause only when penalty is not paid. This aspect requires further adjudication, but in my prima facie view, even if the termination of the contract, imposition of penalty are permissible in terms of the agreement, the forfeiture of security deposit would be guided in this clause by clause 19 of the contract. The matter requires further adjudication. Thus, the security deposit which has been forfeited shall be deposited in a separate interest-bearing fixed deposit, which shall be renewed from time to time till the disposal of the writ petitioner. A copy of the certificate shall be annexed to the affidavit in opposition. Let
Okay,
every
so the
petition be filed
uh,
within a period of 4
such as
weeks.
such, for 4
4
weeks.
weeks. And
So
if
the
they are to even be
security
filed within
deposit,
2 weeks.
security
The
deposit,
monthly list on November 2024. Till today, no affidavit, no nothing. As such, my lord, I am praying before your lordship, your lordship kindly hear the matter.
so security deposit which was forfeited has been kept in a separate account.
Yes.
Huh?
My
As
We
per
do
the
not know-
direction of
We
this.
do not know whether the amount has been kept in the security, in the nationalized bank, I do not know. Now the order was passed by this honorable court on contest. No appeal has been
That has
preferred
been
against
secured,
this
my
order.
lord. That has been
Now, my
automatically
lord, this
secured,
is
my lord.
not a
But I
monthly-
will file the opposition, my lord,
This is
within
not
2
a
weeks, my lord.
monthly-
Kindly fix any date, my lord. In
My
the
lord, I do
meantime,
not- I
it
do
will be
not-
ready, my lord.
How much time was given
My
to
lord,
you?
your lordship,
Well, extension of time, my
This
lord. I'm
order
trying
was
extension of
passed-
time, my lord. Within 2 weeks, fix
This
any date, my
order
lord.
was
In the
passed
meantime,
on-
I will serve.
Please, I do not, your lordship kindly consider, he is not the lawyer in the matter. 4/9/2000.
Okay, since a
4/9/2000.
How come my lord, senior friend is saying I'm not in this
Ah,
matter? I'm
see,
not in this.
Order was passed on
Okay.
4/9/24.
Since a
On-
coordinate bench raised some issue and noted that these issues are required further adjudication and invited affidavit from the respondents.
My lord.
Affidavit has
Ah,
not
Another time.
Affidavit has not been filed, then you
But
lordship kindly hear
within
my
2 weeks,
matter.
I'll serve and file, my lord.
Please, my lord, I will make my
Kindly
submission.
fix any date. Within 2 weeks, I'll
Let him
complete. I'll
submit.
complete, my lord.
My lord, question is,
Okay.
I am suffering a
Without
lot.
affidavit, it cannot be decided, my lord.
My lord, two persons cannot talk together. I am making a submission before your lordship.
Sir,
This
I am
is
also
a-
submitting before my lord.
Yes.
Okay,
I am
2 weeks, 1 week.
I
2
am
weeks,
making-
1 week.
My lord,
I
my
am
lord.
making a
Grateful to you.
Yes.
My lord, kindly consider.
Yes.
My submission, this honorable court passed a direction for certain guideline by laying down certain guideline. And court finds that it is an urgent matter should be heard on contest by filing affidavits.
Yes.
This order was passed on contest on 24th of September 2004 by agreement that we will file within 4 weeks. Till today, affidavit has not been filed. It is a rally authority.
Okay, as a last chance. Yes.
My lord, can it be
Ashwin, yeah.
Your Lordship, since on the last occasion, I could not make, I make some unwanted performance before
No.
receiving the last matter.
It happens, so we don't keep it in mind. Every day it is going on in our life. Yeah.
And
It
on the failure, Your Lordship, on submission, on the failure, they will release my forfeited amount. On their failure to file affidavit, Your Lordship will grant release of forfeited.
No, I am not adjudicating that issue now. Since a coordinate bench says that it requires determination, I should not
Your Lordship has-
pass any order without entering into
Your
the bench.
Lordship, can they
Okay, let them come with their affidavit. Their stand, so far your claim is concerned, will be clear, and then court will decide the issue.
Your Lordship has seen, I was given the contract for 2 years.
Okay, within 90 days they have cancelled and
Only 90
forfeited your security deposit.
and
Yes.
8 lakhs for-
Court has taken note of. Let them justify their answer. Stand.
My-
Don't condemn anyone unhurt. Don't kill anyone. Okay. Allow them to defend their stand. Okay.
Grateful.
Deep down.
Next.
My lord, I am for the Union of India, led by Mr. Arijit Mojumdar. My lord, I am praying for 2 weeks time for the
Why 2 weeks?
for filing affidavit in opposition.
My lord, how long, my lord, kindly see how the petitioner is suffering. My lord, the order passed, last order,
July.
24/7/2024. Last order passed by.
July. Date was fixed, 16th August 2024, reply by a specific date. Not
So
week.
that part is over, my lord. What happened in this matter? Petitioner father died. On the basis of dying and rest, petitioner applied for
Compassionate appointment.
appointment.
They have
They
rejected.
held that against that writ petition was filed, and my lord, the writ petition I have annexed, where it has been held to give, that is, my lord,
No, actually,
page 16.
actually you come to page 27, last paragraph.
That is the after
Most probably you
I'll
find
come before that.
joint application.
Before that, kindly see page 16, order of Justice Lopita Banerjee.
No, how ultimately they stand. You prefer most probably joint application. They say that a single
That I am coming. Kindly see the page 16, the honorable single bench, Justice Lokita Banerjee passed. That is order on 24th of November 22. And the petitioner is suffering. Kindly consider the order.
to consider the representation of the petitioner and dispose of the same. And it is in order. Okay, so they have passed this order.
No. They have not done. Against that, they prepare an appeal.
Paper and appeal. Okay.
Next page.
Okay, paper and appeal.
Page 19, annexure P3.
Okay, appeal was disposed since the point was not argued. We are not entering into that issue.
This is the different bench order.
A policy prevailing at the time of death. Okay.
My
Now
lord.
they raised another issue that joint application.
Now, my lord, last annexure.
Yes.
25, annexure 15. There is another brother who made an application. He never made application. So far I know, two brothers. One is Sanjay Kundu and another is Sanut Kundu. Sanjay Guru is the eldest son. He is younger. He is doing business. That is plastic business in the house. He has not applied for his department in order to avoid the appointment of the petitioner. They have managed. Anyway, we made him the party. Malakali say in the writ petition, Pranod Kundu, respondent number 4, we serve copy, affidavit service in the file. Thereafter, the order passed. He didn't appear because he has no interest. He has no interest. That's why he has not appeared. Now, my lord, again, my lord Justice Mukherjee passed an order to inform the matter will be heard such and such. We inform him. He is not at all interested. In this way, the petitioner is suffering, age is increasing, benefits will be lesser amount ultimately.
Huh?
Benefit, if he joined today, or if he already 6 years passed, Malakali 6, order in the order, it has been.
No, since they have stated if you want to file a single application, it would be necessary protection shall be given that they will consider your application without raising any plea of delay or anything like that.
That part is over. But in the meantime, Malakali see.
Now they are saying it is further.
Page 2, delay 6 years have been passed. That is passed page 2, first third paragraph.
Very recently, a judgment has been passed by the division bench.
Yes,
Delay caused by them could not be attributed to you.
my lord, that is. But also, my lord, single bench order that 6 years already.
Okay, let his her senior come.
No, my lord, I want to move finally. They are not coming because my lord,
Who is your senior?
My lord, Arijit Majumdar.
Arijit Majumdar.
Yes, my lord.
Ask him come tomorrow. Only not today. Okay.
My lord, kindly
So without affidavit, if we can dispose of.
my lord, affidavit in opposition filed within 16th August 2024. Now, March 2025, they have got time to file that. Nothing but in order to delay this matter, and the petitioner is suffering, having a wife and son, bedless, foodless condition. It has been mentioned, my lord. They will file opposition within 16th August 2024. Reply, if any, by 6th September. That long mean then. And a petitioner is before your lordship. He is totally ideal. And they are taking time, they are wasting time. First trial court consider, they have not considered against that paper and appeal. For during the considerable, we have to file contempt application. Thereafter considered. Thereafter, no, the paper and appeal. Appeal was in favor of the petitioner. Now they are dragging my younger brother with me, who is doing a factory in the house. He is not at all interested.
So why she didn't give no?
She has not many. Let them show my brother applied for.
Yes, he has applied.
No, my lord.
No, that no will not
No,
be.
yes, my lord. In the single bench, not a single word ordered by the Union of India. that your brother has appeared. My lord, can you see the order? Single bench, page 16.
Oh,
My lord, kindly see. My lord, kindly see for a second. No mentioning of my brother.
what do you think?
What I am doing, I have made an application for dying harness.
Will you hear the court? Or you will to go on taking upper hand?
No, I will hear the court. I'll not.
You are not allowing to utter any single word to the court.
I'll not say anything. That is up to Lord.
Release the matter from my personal
No,
resolve.
no, my lord. Tomorrow.
Appear if you can respect.
Why?
You don't say by using your voice you will get order.
No. I wanted to show that this is the position and the petitioner before you, your lordship.
Don't think from today I am starting running a court.
No, that is that excitement. I'm sorry.
I am trying to say a single sentence.
Mal,
You are not saying.
mal.
You are saying that by taking voice, I shall take order.
No, tomorrow.
Most probably you are saying one in your experience, man has suddenly come and sit in the court.
No, tomorrow, my lord.
I am releasing the matter.
No,
You
no,
try
no.
your luck before another.
No, my lord. I am extremely sorry. Let it be tomorrow.
Oh, okay.
Let it be tomorrow.
My lord, may I be permitted to mention item number 5 of your lordship's daily list today? I was on my leg. I'm
What?
I'm just praying for not today.
And not this week, at the time of call, it has been made not this week.
But let this matter remain its position. In
Which
the
the other side.
list, it was not appearing at the top time. I have
So
checked
he has heard this order, not this week. Okay, not this week, it will be
let the
retained in
matter
its position.
retain its position in the
Okay,
list.
okay, okay, retain its
Much
position.
obliged. Much obliged.
Okay.
Lord, I am for the state respondent.
But
Yes.
my lord, item number 9, 11, and 12. I was informed by the law clerk of the on record that he is out of station and
Lord,
for some time.
let it be not this week.
Okay, not this week.
My lord, let the matter retain its position.
No, no, not this week. Go down to the list. Everyone should be given opportunity. Okay. Yes, yes. It's 12 পর্যন্ত হয়ে গেল। Oh,
My lord,
9, 11,
My lord, I appear for the petitioner lordship. My lord, they filed their affidavit in opposition. Our reply is ready. There's an interim order which had been passed. We had also filed our written notes at the interim stage itself. And lordship, may we file our reply and we have a supplementary affidavit. My lord, may that be filed, lordship.
supplementary affidavit.
Lordship, because
Have
there's
you
certain.
served the copy?
Have we served it? We've served a copy, lordship.
So why is a supplementary affidavit?
My lord,
supplementary affidavit there is no.
Supplementary affidavit, you must take leave from the court,
lordship,
stating that this
lordship,
supplementary affidavit is
lordship will
required.
kindly grant me a second, lordship.
Okay, you first hand over the
The reply, Lord.
affidavit in reply.
Lordship,
Its copy has been served upon all.
this has been served.
Okay.
This has been served.
কি আছে? ওটা রেকর্ডে নিয়ে নিন, affidavit in reply filed on behalf of the petitioner.
Also filed before this.
তাহলে affidavit exchanged by the parties. No, all parties. Have you filed affidavit? No.
Lord, the Union of India has nothing to do. I appear
Oh,
for the
okay.
Union of India. It is not becoming consistent.
Affidavit in opposition filed on behalf of respondent number 5 and the affidavit in reply, there are 2.
Application, it was inadvertently missed out in the annexures list, which we had served on the respondents, lordship. By this,
7B application.
there's an application which we inadvertently omitted to annex. But the application is with everyone because it is their application. But only that has been brought on record by way of the supplementary. No new document, lordship.
But then again, you have to serve copies on
Lordship,
all
we
the
are
opposite
serving.
parties. Otherwise, without serving a copy, how can you move that? With all
My
the
lord, we have served the supplementary affidavit. We have the receipt as well. It is their lordship. We'll affirm. My lord, I have the tracking report as well, which shows that it's
Union of India is not being served. This does not reflect that the Union of India is being served.
Okay.
My lord, kindly, it's been served, lordship. I have the stamp from Union of India saying that they have received it.
Okay.
So I suppose my learned friend didn't get the instruction.
I know. I have.
Okay, the supplementary affidavit.
But lordship, in the interest of fairness, I'm serving.
Filed on behalf of the petitioner, be kept with the record. Okay. Yes. What the?
My lord, may I just hand this over?
Yes.
आपने भी कोई regional commissioner?
No.
My lord, one thing before my learned friend start, will I submit, my lord? Milord, the real answers to that, the queries that has been raised in the petition can be answered by the Regional Provident Fund Commissioner. Because, Milord, if your Lordship kindly comes to page 137, the main contesting defendant before the trial forum was the Assistant Provident Fund Commissioner. But no one is appearing most probably on the Assistant Provident Fund Commissioner.
Well,
Whether-
they are parties, they've also been served.
Milord,
And when the interim order was passed, they were also
Okay.
represented.
Assistant Provident Fund Commissioner is respondent number 4.
Lordship.
Whether
is the
I have
main
to
contestant?
file affidavit of service.
Well, we had filed affidavit of service and they had appeared also. Lordship will see the order dated 31st July 2024. Mr. J. Rokhit had appeared for the PF.
J. Rokhit for PF authority.
Great, yes, Lordship.
He is main answering respondent.
main answering
My lord,
respondent is there.
since the respondent is saying so, because they had contested this.
But
proceeding.
Union of
I am
India
the
is not.
workman. Mother, document retired in the year 2003. Till date, no retirement benefit has been given.
My lord, that is
I
not
am
the case.
suffering.
They have
I am
got, he
suffering.
had,
They
the
have
petitioner
expert
made a
in
conscious choice.
Expertise.
Okay, you do one thing.
Lordship.
I am making a adjourn for the day.
Lordship.
You serve the copy of supplementary affidavit to all
Yes,
of
today.
them.
Today
We have served already, we'll serve again.
And you gave an intimation to Mr. Rokhit that tomorrow the matter will be taken up for him.
Grateful.
Okay, I am just
Malad, could it be day after tomorrow? My junior has a person.
Oh, okay. Acha, having heard the learned advocate representing the respective parties and upon considering the materials on record, we are of the view that I am of the view that presence of the representative of the PF authority is crucial for effective adjudication of this petition. Stop. Is crucial for effective adjudication of this petition. In view thereof, stop. However, despite service, none appears. Despite service, the PF authority is unrepresented. Stop. In view thereof, the petitioner is directed to give an intimation to the learned advocate who entered appearance on behalf of the PF authority on previous occasion. When the matter was last heard, that the matter shall be taken up for hearing on 13th. On 13th, 2000.
Friday? No, Friday 14th.
Yeah, Friday holiday.
It is Thursday.
We shall enjoy Dole.
Holiday.
Yes.
Lordship is keeping it day after tomorrow, Lordship?
Day after tomorrow,
Yes,
that
Lord.
is
Lord.
13th, yes. Today is 11.
Grateful.
রেকর্ড হ্যাঁ ঠিক আছে আপনার যদি অসুবিধা হয় আপনি পেন যাবেন অসুবিধা হবে না তো এটা আমি তো আস্তে আস্তে হ্যাঁ
My lord, with regard to item number 8 of today's list, my lord, I am paying unconditional apology. I understand. I understand my lord's sentiment. So, my lord, let it be tomorrow. It will be finished.
Okay, tomorrow you try to ensure the presence of your respondent.
If you observe, tomorrow, because of shouting and other thing, I'll inform.
Inform me.
Tomorrow.
Oh, tomorrow. Okay. Yes. 13. Okay. Which for your other side?
I have copy, my lord, the restoration application, my lord, kindly restore the matter and my lord, any day fixed.
No, today is the first day. Whether it would be appropriate to take up the matter in their absence
Well, I
today.
have the copy.
From tomorrow and onwards, it would be.
I have the copy restoration application, immediate service, my lord. Kindly restore the matter, my lord, any day fixed, my lord.
Restore.
I only prayer for this.
Limitation is there.
Yes, my lord, some limitation.
Where is the section 5 application?
Same.
So section 5 has not been filed. When the matter was dismissed for default.
2000.
10th February 2012. When you have filed the same.
I filed my lord 2000.
2021.
Yes, my lord, I
9 years.
some advocate change, advocates.
So you file application for say, condonation of delay. You file, explain the delay.
Prepare here, my lord.
No liberty is given. I'm just directing that let the matter go out of list.
No, my lord.
You file and mention. You file and mention. But explain the delay properly. I am sitting, getting occasion to sit in the division bench. We are seeing, we are really hard that nowadays Section 5 is drafted in such a way, we are not at all satisfied. And if any order is challenged before the Honorable Supreme Court, that would be rejected. That would be set aside. No explanation is being given. Try to cover up the period. When it was dismissed, then when it came to your knowledge, when you are apply for the apply for certified copy, or if certified copy is not applied, then when you file, what was the reason for delay? No, not day-to-day explanation is not required. Day-to-day explanation not, but delay must be sufficiently explained.
My lord, kindly fix 2 weeks. After 2 weeks, my lord. In the meantime, I filed the Section 5.
As Mr. Planet Advocate defending the petitioner, pays for accommodation for a period of 2 weeks to take appropriate steps. In view of submission, the matter, let the matter appear after 2 weeks. ঠিক আছে কি বললাম লাস্ট এখানে লাইনটা প্রথম লাইনটা ফার্স্ট লাইনটা Section D letter, let the matter appear 2 weeks. Acha, after 2 weeks. Okay. Next.
Item number 40. This similar issue. My lord, in this matter, the matter was dismissed for default. I have come up with 2 applications. One is Section 5 and another is, my lord, restoration.
Okay, who is your other side?
I have served the copy, my lord, and effectively it is served. In spite of service, they are having no interest. Lordship, the 116 days delays. And I have explained. On 5th of December, Lordship was pleased to dismiss for default. Due to non-appearance, erstwhile lawyer neither given the papers nor had taken any step. I am for Food Corporation, my lord. Secondly, another advocate appointed, Mr. Saptarshi Dutt, now who is on record on behalf of the petitioner. Lordship, appointment of the lawyers, thereafter availability of the papers, I have made categorically clear the delay on my part in my Section 5
Okay,
application.
do it tomorrow. That would be better. Today is the first date I am sitting. Do it tomorrow.
In that event, Lordship,
And you would try to give an intimation to the learned advocate who
no, till this moment, who will appear, it is not in my knowledge as to why.
Assistant Provisional Fund Commissioner. It is Mr. Rokit, Mr. Another.
Restoration. If Lordship kindly restore, no harm in it.
Tomorrow, it will be done tomorrow. If they don't come. Tomorrow it will be done.
Lordship, can it be day after 2?
Day after tomorrow.
I've got some difficulty.
Okay, day after.
Obliged.
Date দিয়ে দেবেন তো না day after 13/3.
15-minute time for the petition.
Who is your other side?
The joint account is appearing for the state.
Give an intimation and come tomorrow. That would be better. Lynn.
I'm appearing for the petition, I'm praying for not this week.
Okay, not this week. Bottom of the list.
17-minute time. Here, Miss Supriya Dubey is appearing for district service commission.
Okay, not today. It will be written. Come tomorrow. Okay. The কেউ রেসপন্স করছে না, go down. Same. 24. And for the petitioner. That matter? Yes, madam. Indrajit Dasgupta. Indrajit Dasgupta is my. Okay, it will retain in the list. You just give an intimation. I think he will appear. But it will appear. It will be my lord's pleasure to hear this matter on Thursday day after tomorrow. Okay, okay. And it will retain his position. Huh? The matter will retain his position. Ah, yes, retain his position. And actually inform Mr. Gupta. Yes. Indrajit Dasgupta. Oh.
Permitted to mention item number 19. I am for the petitioner. This is for the restoration of application, Lordship.
Item number 19.
Yes, Lord.
19 it has been passed over. Who is your other side?
Actually, sir, Lordship, I have served thrice before upon the learned advocates of the state. Advocates.
Do you know who is the learned advocate for the
Yes.
state?
Yes, Lordship.
Okay, you give an intimation that tomorrow
Yes,
matter will be taken up for hearing.
I have
And 19th now হবে না 19th tomorrow. ঠিক আছে? Okay. Come tomorrow. In the meantime, you give an intimation to the learned advocate. Today is the first day court is sitting. And hence I am not taking matter in absence of any advocate. Okay. But tomorrow and onwards, then according to usual course, the matter. Yes. Regular basis, I don't know. No. Okay, 26. 27. Hmm. 31. 32. 33. 34. 35. 36. 37. 38. 39. 40. 41. 42. 43. 44. 45. 6.
What was the time for the petitioner mother praying for not today?
Not this week. Or not today.
Not today.
Tomorrow you will do.
Well, Mr. Kunal Ganguly is the advocate on record, my lord. On his instruction, I am praying for not.
Whether tomorrow will do or not this week.
I need to take instruction.
Take decision whether you are so hesitating. We'll come on this chair tomorrow. So be quick in taking decision. Okay, not this week. Not this week. এটা করবেন না, তলা না হবেন এটা রেখে Okay, next.
47 therefore the petitioner check up for the secretary clear
Okay, 13.
49, I am for the petitioner mother praying for not this week.
Not this week.
Mr. Ujjwal Rai is appearing, my lord. I was humbly praying for one day accommodation.
Tomorrow you will do. But do you know who is appearing for your other side?
My lord, in this matter, my lord, for the commission, Dr. Sutanu Patra is appearing, my lord.
Okay, give information.
My lord, I will.
Okay, not today.
So 62 legal SSR
30.
8,
64, 65, 66, 7.
Lordship 67, I am for the petitioner, Lordship. Lordship, on several occasions, I have served upon the state authority and they have, they are not.
Okay, you take trouble to serve again, intimating that the matter is running in this list, and tomorrow the matter may be taken up
Lordship.
for hearing. Okay,
I am
okay, keep it with you. Keep it
Lordship.
with you. Today is the first day when the court is started sitting. You give a intimation that tomorrow the matter it is running in the list. In this way, you give a notice.
Deeply obliged, Lordship.
9, 17, 71, 72.
72 petitioner, my lord, I am appearing for the petitioner in this matter.
Who is your other side?
Other side, District Primary School Council, Paschim Midnapur, Ranjan Saha probably will replace.
Ask your junior to give an intimation tomorrow.
Yes, sure.
As
Matter, my lord, may be taken up tomorrow, madam.
tomorrow, yes. Tomorrow it is 72.
Slightly up.
72 একটু update করে দিন।
Upgrade করে দিন। Grateful, deeply obliged.
73, 74, 75, 76, 77, 78.
My lord, I am for the petitioner led by Ms. Sonam Basu. My lord, I have not received any affidavit in opposition in this
You are
matter.
for the petitioner.
Yes, my lord.
They have not filed any affidavit in opposition.
No, my lord.
Okay, what can be done? Let them come. Okay.
Well, item number 29.
Item number?
29, my lord.
You are for the petitioner.
Yes, ma'am.
So do it tomorrow, being your other side tomorrow. Give
My lord,
an
what happened in this matter, your lordship directed me to serve a notice. I have served notice. Upon the respondents, I have filed affidavit of service also, my lord. What happened?
Okay, it would not be, it will not go down in the list. It would be taken up tomorrow. Okay.
Tomorrow.
Tomorrow, yes.
Tomorrow, my lord, or Monday.
Okay, not this week. Not this week, but it will not go down.
Right.
Okay, not this week.
But it will not go to the bottom, my lord.
No, you give an intimation to your other.
No, I have given you what happened, my lord.
Now, who is the learned advocate?
Learned advocate, my lord, I have given directly because I do not know. I have served upon the regional labor commissioner. Yes, Kamalakha Prasad Rai also sent.
You give an intimation to him.
Kamalakha Prasad Rai, I informed that he expired.
Expired.
Private respondent. And regional labor commission, they have received.
Answering respondent, who is answering respondent?
Answering respondent is the affected party, is the private respondent. Because
so representative of private respondent is required.
Required, my lord.
Okay, you try to who entered appearance on his behalf. If you can give a notice to your. So not this week.
Not this.
That means it would be taken up on Monday. In the meantime, you give notice. Okay. Item 71, 79.
29, 29.
80.
29 alone. No, 20.
Lordship, Mrs. Chandrayalam is appearing on behalf of the respondent. She is
80.
Out of station. She is out of station. Praying for not this week.
So when will be in station, then you will mention go out of list.
Lordship, she is going to the ballot for medical issues.
Okay, not this week. Will
Not this
be sufficient. Okay, not this week.
But I am pleased for matter item 75. Also, I am for the petitioner, no one for the respondent. Maybe tomorrow along with item 70.
Okay, tomorrow. Try your luck.
Same 48, 48, 48,
48 tomorrow. If both sides are there, both sides.
Today I don't find it.
Oh. 48 tomorrow.
But same, my lord, my prayer with respect to 61. 61.
61. You intimate your other
Yes, yes,
side.
yes, my lord. Immediately I'm just calling him the other side.
You intimate your other side.
But let it be, my lord, tomorrow 61 and 68, both of them, the other side, my lord, is there. I know their mobile numbers as well. I'll once again give me a call.
Yes, yes.
I'll also do that, but I'll also.
কার কথা?
61 and 68.
Okay. Any other matter where both sides are there?
So 70 over also one by matter.
এই 70টাও করে দিন।
70 by
Not
matter.
today, কালকে।
70, 75 are.
হ্যাঁ।
As you
ঠিক আছে।
My lord, in respect of item number 34 to 37, my lord, those are old matter, my lord. Files has been lost, my lord, your lordship, kindly make it, my lord, next monthly list, your lordship. In the meantime, my lord, I have already applied for certified copy and I said got it, my lord.
Number?
34 to 37, my lord.
34 to 37. So let the matter go out of list with liberty to mention.
Let it remain in the list, my lord, otherwise I shall be, my lord, no here, my lord.
Unnecessary list will be lengthy. Go out of list, liberty to mention.
Already I have applied for certified copy of the documents, my lord, before your lordship.
The file you mentioned, the matter will be included in that.
As your lordship, as your lordship, my lord, as your lordship.
এটা লিখুন তো 34 to 37. Based on the fear made on behalf of the petitioner, let the matter go out of list. Stop, liberty to mention.
My lord, with the liberty to mention, your lordship, kindly.
And liberty to mention. Yes.
Grateful to your lordship.
আপনি একটু আসুন। কোথায় গেল? এই 56, 26. Okay, same order, go out of list, liberty to mention. Okay.